The litigation in Idaho versus Bryan Kohberger has been extensive. That is not unexpected. That is not a surprise to anyone. This is a case where the state is seeking the death penalty. It is a quadruple homicide. It is a case with 51 terabytes of digital evidence. The defense is still fighting with the state over discovery. There is DNA evidence. This is not only an extensive digital case, but the litigation has been so ongoing. And that has led us to a very early motion for change of venue. Often we see the change of venue closer to trial. It took over a year to set a trial date in this case, and the court finally set a trial date for the summer of 2025. The defense, I think, out of an abundance of caution, brought the motion for change of venue at the earliest possible point because they didn't want to end up getting to the summer of 2025, starting to get affidavits back from jurors and go, we can't have a trial here. We can't find a jury. Yes, there is the remedy of potentially bringing in new jurors and widening the jury pool. The argument when we got to these motions in court was that Latah County is a large enough county that they can expand the pool and bring in 1,800, 2,000 jurors to find a jury of 18. So they can go for 1 in 100. And they have enough people in the county to do that are of the appropriate age to sit on a jury. The defense argued that the press coverage, the media coverage of this case has been so overwhelming and so unfavorable that there is no way that Bryan Kohberger can get a fair trial in Latah County. I was not sure how quickly Judge Judge would rule. He indicated this was going to take him some time. He said that this was one of the most profound, serious motions that he's ever had to consider, which makes me wonder what kind of cases he normally does when the change of venue is like the most profound thing that he has had to do in court. But he said this was one of the biggest motions he's considered. Judge Judge cannot make anything an email. He likes to hear what's going to be presented in court. The defense presented everything they presented in court in writing very thoroughly. They brought it in court in case the judge wanted to ask questions and to make that record more fully with live testimony. They brought in numerous experts to talk about the amount of media, the type of media, and then to talk about subconscious and unconscious bias and whether jurors who have been exposed to this kind of media can come into a court with an open mind when it comes to Bryan Kohberger, when they've been exposed to that kind of media, and that even if they say, yes, I can go into this case with an open mind, saying that even if they say that, it's not necessarily true. The prosecution said, look, there's been media all over the state. The numbers in Boise County and Ada County are not that different than the numbers of media coverage here in Latah County. So all things the same, it should stay in Latah County. Those were the arguments by both of the parties. The judge ruled sooner than I thought he would. I'm sure you all saw the headlines. This ruling came down yesterday, Monday, September 6th, and the court granted the defendant's motion for change of venue. Going through all of the judge's 20-plus page order, in this case, transferring venue, we see that Judge Judge very much cited the language of the law to transfer this case to the state Supreme Court to pick a venue. So it is not known where this case is going just yet. The Idaho Supreme Court will decide, and to assign a judge. Will that be Judge Judge? It's unlikely. I think the law contemplates assigning a judge within the county where it gets transferred to. Could John Judge have chosen to stay on this case? Yes. Judges stay with cases all the time. Will a new judge getting assigned delay this case? I hope not, but courtroom availability might. We'll see what happens when the state Supreme Court reassigns it. What was interesting is that Judge Judge not only found that the defense had met their burden, albeit a low burden, to show that there was a presumptive prejudice based on the media and publicity in this case, but the judge also noted on his own that even if the defense hadn't met their burden, that this still needed to be transferred in the interest of justice because it simply was not possible to hold this trial in Latah County. The one court clerk who deals with juries cannot summon as many jurors as is needed. And the court lined out that some 6,000 jury summonses would need to be sent out to ultimately survey about 1,800 jurors, and they would need court clerks and equipment from outside counties to come into Latah. And that's before you get to security issues. That's before you get to the impracticability of the courtroom layout. And that's before you get to the fact that the jury room can't even accommodate 18 jurors for 3 months because it simply is not large enough. And there is nowhere for the defense attorneys to work. There is real issues of the size and structure of the courthouse, and there is no good way to get witnesses in and out of court outside of public view. So for all those reasons, the judge, it seems, would have moved venue no matter what, just based on the inability of Latah County to have this trial. And I went over the response provided by the Goncalves family to Bryan Enton, saying that they are frustrated, that they think that the court put the non-dissemination order in place to make sure there wasn't overwhelming, unfair, and prejudicial publicity to keep this case in Latah County, which was their fervent desire, and expressed a frustration that they feel very kept out of the process and not considered in it, and that the inconvenience with this case getting moved leaves them again out in the cold while they are going through this case, when they said they are the most invested in the outcome. So it is clearly frustrating to at least victim Goncalves' families, and we will see what the Supreme Court in Idaho decides to do. Where will this case go? Probably Ada County, where Boise is. And will Judge get volunteered for it? Or will a judge from Ada County be the one taking it over? And I think that's probably what is going to happen. Will this bump back the trial date? It's unknown. We're still less than a year out, so there might be enough time. It is an extensive case. There are a lot of motions outstanding. There are a lot of discovery issues outstanding. So there is a tremendous amount of work that still needs to be done in this case, and we will see where it ends up when the Supreme Court rules. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.